Welcome back. Now, the Supreme Court has ordered the Electoral Commission to take steps to immediately delete the names of some 56,000 or more persons who use the NHIS cards as proof of identity to register as voters. The court further ordered that these persons should be re-registered in order not to disenfranchise them using a different form of identity. The court said it cannot alter its earlier ruling since it was clear on the orders in the May 5 judgment.
Security at the Supreme Court was tight. Former youth organizer of the PNC and one Evans Nimakon filed an application at the Apex Court for a clarification of the May 5 judgment ordering the Electoral Commission to immediately delete names of persons who registered with the NHIS card. The court in its ruling on Tuesday, July 5, told the EC to give opportunities to the 56,000 affected persons to re-register using the right process in order not to disenfranchise them in the upcoming elections. The Apex Court also ordered the Commission to delete names of persons not included in the list submitted to it but had registered with the NHIS card. This order gives the opportunity to individuals and groups to submit names of NHIS registrants to the Commission to delete accordingly. The Commission was further directed to give adequate notice to the affected persons in reference to the registration process. The plaintiffs in their application also sought a relief for the Commission to adopt a validation process to delete the affected names. The court dismissed the relief, stating the plaintiffs were in court to seek clarification but decided to repackage the earlier relief, which it described as unreasonable. The Supreme Court dismissed an application by the plaintiffs objecting to some anomalies in the list submitted to the court, saying the plaintiffs were in court for clarification and not to seek any other relief.
Still with the Supreme Court, the Apex Court has issued a warrant for two panelists who are alleged to have threatened judges. The host and the owner of Muntie FM are to appear before the court. The individuals who have been cited for contempt are to appear before the Apex Court to explain why they should not be punished for the threats they have allegedly made.
Crab-based Muntie FM, the two panelists who allegedly threatened the lives of Supreme Court and High Court judges, as well as the host of the show, have been cited for contempt. The judges on Tuesday, July 5, issued a warrant for them to appear before them to answer contempt charges. The two, Alistair Nelson and Godwin Akogan, allegedly threatened to eliminate the Supreme Court judges if they made any judgment against the Electoral Commission in the ongoing court case challenging the validity of the voters' register. The judges said they were terrified by Muntie FM panelists' threat.
Right, so on the line now we have Justice Srem Sai, who is a senior lecturer at the the Gimpa Law Faculty. Good evening, sir. Thank you very much for joining us.
Yeah, good evening.
So this warrant, let me take your thoughts on the warrant that have been issued by the Supreme Court for the owner of Muntie FM and the two panelists to appear before the court. What really does this mean? Hello, sir.
Hello, yeah.
Yes, sir.
Sorry.
Did you hear me?
The question again.
Yeah, right. I was asking that I'm sure you may have followed the news that the Supreme Court has ordered a warrant for the owner of Muntie FM and the panelists, the two panelists who allegedly made threats against the Supreme Court and High Court judges to appear before it. I'm asking what really this will mean in legal terms and what the consequences might be.
Thank you very much. Generally, that will mean that the named persons are supposed to appear before the court, as the order said, to show cause why, certain actions should not be taken against them. And I think that's
clear enough. Yeah. And this does this have punitive undertones? For example, if they decide not to go, are there repercussions?
No one, not even the head of state, can refuse a court order. So definitely, if they refuse to go, then definitely consequences will follow.
Okay.
And this is the Supreme Court, for God's sake. This is the Supreme Court which has issued a warrant for you to appear before them. How dare do you say that you won't? It's not, without consequences, right. I doubt.
Right. So let's now go back to our substantive discussion for tonight. The issue of the order by the Supreme Court for the Electoral Commission to take steps to delete some 56,000 or so people in the voters register. I know that this case has generated a lot of excitement. There are those who claim that this is clear enough and should put the matter to rest. But do you think that actually this brings clarity, the kind of clarity that Abu Ramadan and co were seeking?
I listened to the plaintiffs and their lawyers, and it appears they are satisfied with the explanation given. So from that perspective, I mean, from the plaintiff's perspective, we can say that there is clarity. However, clarity, so long as you have more than one person, interested in the judgment, then we cannot say that it's clear enough. But what we can say at this point is that it is clearer, because as you probably know, and I heard you on the news, there appears to be some kind of timeline given to and some more specific direction. If you compare what was given by the court today to what was given on May 5, then you probably will know that there's clarity, because May 5, the order says, okay, take steps to, correct anomaly or to correct what we are complaining of. And then now we are saying that, okay, not just take steps, but do it forthwith. Now, of course, questions will come as to what we mean by forthwith. Does that mean that the names must be deleted probably tonight, tomorrow morning, as soon as possible, as soon as practicable? These are other issues
And then there are also other issues. I must say that the May 5 judgment, among other things, the court ordered the Electoral Commission should put in writing the steps that it was going to use to delete these names. And there are those who are saying that this didn't surface in this final ruling or order today. Do you think that this is going to be problematic, since you and I mean, those of us who are not at the Supreme Court and don't know whether the Electoral Commission has honored that aspect of the May 5 ruling to put in writing, we will not know what steps the EC will take to delete the names, especially considering the fact that CI 91 might still be valid law to be used by the...
No, so the EC's main argument since May 5 has been that, look, we already have in place by CI 91 processes that we need to go through to get the register cleaned. And we are going to go by the CI 91 provision. And indeed, the court itself acknowledged that there were laws in place according to which the Electoral Commission was supposed to operate. So the initial understanding was that, well, since the court mentioned in its judgment that there were laws in place and those laws were not unknown, those laws were contained in CI 91, then we can say that that is what the court intended the EC to go by. Now, the clarification now is that whatever the court has directed supersedes what is in CI 91. And the court said, one, delete the names forthwith, and then after that, make sure you find a way of re-registering the people. And all this should be done before the election, which is scheduled for November 7th. Now, the question is, the practicability or the implementation aspect of this is something that we can always, discuss. For example, the EC is working with resources and other things. So deleting the names, that is fine. But there's even another legal question which arises out of this situation. Okay? It is fundamental rule of law that a person's rights, no matter how faint, no matter how feeble, cannot be taken away without giving the person a fair hearing.
Yeah.
And fair hearing means that when you are going to take a decision which will be adverse to your interest, we need to hear your side of the story first. It is a well-established principle of law under the common law and even in the Ghanaian jurisprudence. So it is something that we lawyers consider as a cardinal principle. Now, if I understand the Supreme Court to be saying that delete the name first and then hear the people later, actually qualified, then I am tempted to believe at this point that then that cardinal principle of law, which says that to take an adverse decision against someone, okay, we should give the person fair hearing first. It's been, it's been in a way whittled down in the sense that now we are going to take a decision that is going to affect, but that will not affect the EC's, obedience of the order. The EC is bound, like any one of us, to obey the court order, no matter what issues may be raised.
Now, my final question to you. There are those who also say that the order of the Supreme Court has introduced a certain element of ambiguity to the extent that the court said EC must go ahead to delete the over 56,000 people whose names are on the register and those whose names were not submitted, were not part of the list submitted to the Electoral Commission. That actually opens a lot of ambiguous avenues for this to be achieved. One, we don't know what the number is. We don't know how many people put their names on the register using the NHIS cards, and yet the Electoral Commission could not put their names on the list to present to the Supreme Court. This actually opens a floodgate. You wouldn't think so?
No, I don't think so. This is what is happening. The court earlier made a determination that if you register with an NHIS card, then, you have not registered properly. You may agree or disagree with that decision, but that's what the court seems to be saying. Now, what the court has done is to prevent a situation where you find one person with NHIS card, and then that person, you must bring that to court for an order to be made. So instead of going by on one basis, the court has made a subsequent order saying that anytime you find someone whose name is on the register,
go ahead and delete without coming to court.
Yeah, you don't need to come to the Supreme Court to get an order to go and remove that name.
Right,
go ahead and remove the name. That is basically what it means. So it's not ambiguous as far as I'm concerned. I don't think there's any ambiguity in that aspect of the order.
Right, Justice I, we're grateful. Thank you very much. Justice Srem Sai is Senior Law Lecturer at the GIMPA Law Faculty.